appeal in the matter of Siddique, Hakim, Adam and HDI Global Specialty SE.
Yes, Mr. Bailey.
May it please the court, I appear in this matter on behalf of the appellants, together with my learned friends Mr. Ali Sinai and Mr. James Reckitt. Mr. David Halburn, King's Counsel, and Mr. James Mallum appear on behalf of the defendant insurers. My learned friends Mr. Ben Lynch, King's Counsel, and Miss Gillian Hughes appear on behalf of the interveners, the Financial Services Compensation Scheme Limited. As your lordships were and my lady will know, these are second appeals from an order of His Honour Judge Khan dismissing an appeal from an order of District Judge Clarke, whereby he dismissed the appellant's claims against the insurers on the grounds that they were barred by the statute of limitations. Now, the appeals, the second appeals are brought with permission granted by my Lord Justice Lewison, and the Financial Services Compensation Scheme Limited granted permission to intervene by an order made by my Lady Justice Andrews. The order granting permission to appeal is in the core bundle 1. If we're working from hard copy bundles, there should be 2 volumes of the core bundle. This is core bundle 1 at tab 8, page 86.
Do you want us to look at that?
Very briefly, it identifies the reason, bearing in mind that it has to be a compelling one for permission for a second appeal. And paragraph 1 of the reasons which we've submitted is entirely right, is the grounds of appeal in particular, whether FSCS versus Larnell, which is a Court of Appeal decision from 2005, which we no doubt will look at, applies the alternative route provided by the 2010 Act, raises a question of principle with potentially far-reaching consequences. It ought to be decided definitively by the Court of Appeal. And the other order, if I can just very briefly take you to it, because there is a point that arises out of it, is the order of my Lady Justice Andrews, which we see in the same bundle at tab 10, page 93. And if I could just direct you very briefly to paragraph 2, and in particular paragraph 2C, whereby FSCS is granted permission to make oral submissions at the hearing of these appeals of no more than 1 hour. Now,
that was when there were 2 appeals.
I beg your pardon, my lord?
That was when there were 2 appeals, of course.
Well, indeed that is true. Now, as far as running order is concerned, subject to any observations from the court, obviously it's agreed that I should open the appeals, and then I should be followed by Mr. Lynch on behalf of the interveners, and then Mr. Halpern will make his submissions on behalf of the respondents, and I will then reply. The issue on which the parties haven't reached agreement is whether FSCS, who have were granted at least 1 hour by this order, should be able to reserve a little bit of that time, say 10 to 15 minutes, for a short reply. Now, from the appellant's side, for my part, I certainly have no objection to that course, and indeed consider giving FSCS a short reply once all the submissions are being heard may well assist the court. But indeed, the real question, it seems to me, on whether they should have a short right to reply is what the court would find most helpful. That's the point on which.
Well, I think until we've actually heard some submissions, it's a bit difficult to say. Maybe that when we've heard the submissions, we think some further submissions from Ms. Lynch might be helpful. We might say, we've heard enough, thank you very much. So why don't we just play it by ear, Mr. Bailey?
My lord, I'm very happy to play it by ear, my lord. Now, in terms of the time estimate overall, my lord, originally these appeals were set down for 3 days. And that was, of course, when there was the Rashid appeal as well as this one being heard consecutively or concurrently. Now, the parties have agreed, given the fact that the Rashid appeal is settled, that the current estimate could be reduced to at least 2.5 days. Now, that estimate effectively assumes that I'm going to take up the whole of today.
Well, I was going to say, we, that is the court, would be surprised if you need 2.5 days for this case.
Well, my lord,
but,
it seemed to me that it may well be possible, if not highly desirable for everybody concerned, if we could complete this hearing in 2 days.
Yes.
And what I was going to say
let's
is...
see if we can do that. If we can't, we can't, but let's see if we can do it.
Well, my lord, indeed. Perhaps what we can do is revisit the question of the estimate at the end of today. And I certainly hope because it's always difficult to tell, but I hope that I might be able to allow Mr. Lynch to finish his submission today as well.
Yep.
So, my lord, against that background, can I just briefly explain the course that I propose to adopt
Yeah.
in making my oral submissions? And so the court knows where I'm going, what I'm going to do is divide my oral submissions into 4 parts. The first part is just a very brief and hopefully uncontroversial review of the basic facts and procedural background. Shouldn't take too long, but just to show your lordships and my lady the key documents. Secondly, and this is the heart of my argument, I propose to articulate the appellant's core submissions on the 2010 Act and on the key issues that arise on these appeals. And after doing that, the third section of my oral argument will be to make some brief submissions on the judgments below. They're set out in writing already, but there's 1 or 2 points I want to highlight. And then finally, I propose to make some short submissions on the respondent's notice points that have been made by HDI. So that's the basic structure. And if I may therefore begin with part 1, the facts of the background.
Yeah.
And as the court knows, this is a hearing of 3 linked appeals now, in the name of Siddique, Hacking and Allen. And in fact, there's no material difference between the 3 appeals in relation to the points of principle that arise. So what I propose to do, rather than going through all of them, is simply to take the Allen appeal for the purposes of this exercise. And perhaps we can start, my lords, my lady, with the supplemental bundle in the Siddique appeals.
Supplemental bundle
in Siddique.
Yep.
And the 2 bundles we'd like to use are this one and core bundle 2.
Right.
So just so we can see it, what we have at tab 2 on page 28 is the order, the compulsory winding up order that was made by District Judge Baker on the 4th of March in Liverpool, and whereby Heatwave Energy Solutions Ltd, which for the rest of my submissions I'm simply going to refer to as Heatwave, was wound up. So that happened on the 4th of March 2019. A letter before action was sent on behalf of Mr. Allen on the 6th of July. We see that at tab 22 of the same bundle.
6th of July 2020.
6th of July 2020, yes.
Yep.
So the following year. So, and the letter begins at page 95. I don't need to take you through it in any detail at all.
No.
But just so you can see, it is in paragraph 3. It's the pre-action protocol which the CPR requires one to send in relation to construction engineering disputes. Paragraph 2 explains the very basic background to the claim in relation to the installation of cavity wall insulation at the claimant's property, which caused damage on the claimant's case to the property itself. The paragraphs that are possibly worth looking at are on page 98 to 99. Paragraphs 35 to 39, and paragraphs 35 and 36 deal with the basic principles of limitation. But then over the page at 37, so we know that the installer, that's Heatwave, is in liquidation, and in accordance with Taft's Wells Limited and Northern Ontario Power, therefore time stops running for limitation purposes, whether the liquidation is compulsory or voluntary, unless and until liquidation turns into dissolution. And then there's reference to the fact there is the opportunity to restore a company within 6 years having been dissolved. And there's a reservation in paragraph 39 to pursue the claim against Heatwave Energy Solutions accordingly, namely the insolvent insured. So that was the pre-action protocol letter. It wasn't responded to, and therefore a claim form was issued, and we can see at page 103, the next document in the bundle, that was received by the County Court on the 14th of October 2020. Now 14th of October 2020 therefore is, for the purpose of limitation, the date that the claim was commenced. Now if we can then go back to put that bundle, I think, aside, perhaps not completely away but aside, if we go please to core bundle 2.
So date of knowledge, October 2015, see page 98. Claim form, October 2020.
My lord, yes, there's the point is that the claim, the period of limitation hadn't expired by the date of the winding up order.
No, I follow that.
That's the key point we make. But you're quite right, my lord, about
They actually claimed that the relevant date was October 2017. There might have been some debate about that, but for those purposes it doesn't really matter. The claim's brought within the limitation period either way.
indeed, my lady, that's
Yeah.
right. So if you please then go to core bundle 2. And the claim form as served is at tab 60. And at page 346. Now, what you'll note about this document is the fact that it was amended before service to delete the first defendant as a party. The first defendant, when it was initially issued, was Heatwave, the company in liquidation. So that party was deleted, leaving the sole defendant as being HDI Global Specialty, the insurers, the respondents to this appeal. And the other amendments that were made, you can see in red, are the claimants seek declarations pursuant to sections 22A and 22B and 211 of the Third Parties Rights Against Insurers Act 2010, together with judgment and damages, including general damage and interest in respect of the defendant's liability to the claimants as insurer of the installer. So the claim, when served, was a claim solely against the insurers pursuant to the 2010 Act. Particulars of claim were served in February, and they are to be found at page 348 of the same bundle. There is an error in paragraph 2, not particularly matters, in the sense that the installer was placed into liquidation under the Insolvency Act on the 20th of March. That should be the 4th of March.
Yeah.
In fact, subsequently in the same pleading, the correct date's there, and so it's a point of no real consequence. And then the way in which the particulars are broken down is the first section, the claim against the defendant, paragraphs 4 to 7, explain the background to how the claim arises, namely that the property was not suffering from damp, but then a representative of the Heatwave knocked on the claimant's door in August of 2013, basically offered to do free CWI on the basis, as it subsequently transpired, that having done so, that company would receive payment from the government. So that's the circumstances in which the House came to have CWI, as if I may respectfully call it, installed within it, which led to, on the claimant's case, property damage being sustained, and for reasons that are set out, as a result of a breach of contract, breach of duties of care and negligence on the part of the installers, namely Heatwave. The property suffered physical damage as a consequence, and we can see at page 356, or it begins at 355, the particulars of loss and damage, and the costs for rectifying and remedying the condition and structure of the property are thought to be in the order of somewhere in the order of £40,000 or odd £1,000. So the loss that Mr. Allen suffered is in the order of £40,000 as a result of the negligence and breach of contract on the part of Heatwave. So having set that out, in other words, the liability of Heatwave to Mr. Allen, the final section of the points of claim deals with a claim under the 2010 Act. Paragraph 21, and this is where the correct date is pleaded. Upon placed in liquidation on the 4th of March, the installer became a relevant person. That, I believe, is common ground. Pursuant to the contract of insurance, International Insurance Company of Hanover, which, as we'll see in a moment, that was the previous name. HDI effectively became, or rather Hanover changed its name to HDI, I think in 2019, agreed to provide the installer with public liability insurance under a combined liability policy. And the period of cover is pleaded. A copy of the insurance policy is attached, and it said responsibility of the insurance policy now rests with the defendant. Well, that's true, but that's simply because of a change of name. It's then pleaded that under the policy, the defendant is responsible for indemnifying Heatwave, and then in paragraph 27, the effective transfer that's caused by the 2010 Act upon a person becoming a relevant person is pleaded. And then the key part, for present purposes, are paragraphs 28 and 29. Now, paragraph 28, the claimant seeks the following declarations. A declaration as the installer's liability to the claimant for the claim set out under the heading the claim against the defendant above. Now, that effectively is
22A.
22A, exactly, my lord, as indeed set out in the claim form as amended. And little M, I don't know why it's come out as M, but it should be B really. A declaration as the defendant's liability to the claimant, that's 22B.
Yeah.
And then there is the claim, the consequential claim, which arises under section 2 for an award, an appropriate award of damages, and then interest pleaded. So that's the way in which the case has been pleaded. And in my respectful submission, it is important to recognise that the claims that are being pleaded at this stage are under section 2, and they consist primarily of the two declarations, 22A and 22B. And in terms of limitations, as we'll discover, and as your lordships will know, my lady will know, the actual claim under the policy does not accrue unless and until liability is established. It's only by reference to a procedural right afforded by the 2010 Act that it's possible for the claimants to make a claim for a declaration against the defendant in relation to a cause of action it has against Heatwave. And we'll come on to the significance of that when I come to my core submissions, but that's the nature of the claim that's being made. We then, if I briefly take you to the defence. Again, I hope not to labour this and try and take it as quickly as possible. Nothing much turns on this, although it is significant to see the points that arise. Now, the defence is at tab 62, beginning of page 361. And what I want to show you in particular is paragraph 4. This is the paragraph where the plea, the limitation plea, is pleaded by the defendant insurers. And it's highly significant, my submission, because it actually analytically correctly identifies the basis on which an insurer could have a limitation defence in relation to a claim brought under 22A for a declaration, which is the only claim that could possibly be time barred or statute barred at the time the proceedings were commenced. And what's pleaded in paragraph 4 is this: pursuant to section 2.4, and we'll come on to look at that because this is a very significant section. Pursuant to section 2.4 of the 2010 Act, the defendant is entitled to the benefit of any defence upon which the installer would have been, that's Heatwave, the installer would have been entitled to rely in response to the claimant's claim against it. Now, I totally agree with that. That's entirely right. That is the effect of 2.4. The insurers stand in the shoes of Heatwave and they have the benefit of any defence that the installer could have taken had the claim been brought against the installer. So that's the way in which plea is put, and then it goes on to say the defendant notes the proceedings herein were received on the 14th of October, whereas the claimant alleges that the installer carried its work out on the property on or around the 4th of November 2013. And then over the page, whilst the damage was noted by the claimant in October 2015, the damage to the property began almost immediately following the installation of the CWI. Consequently, any claim in contract against the installer is statute barred, and any claim in tort against the installer is statute barred, damage having first been suffered by the claimant prior to 14th of October 2014. So that's the way in which it's put, and then the issues will, as we see when we look at the judgments below, is to what's the significance, if anything, of the fact that the statutory time limit had not expired at the time when the company was placed into compulsory liquidation on the 4th of March 2019. And that's the key issue that arises on limitation. Now, just to briefly go on, having pleaded limitation, it is significant to note that the pleader, on behalf of the insurers, then takes a raft of additional points. The first chunk of which deals with, so for paragraph 5 through to 26, deals with the defence to the claim for a declaration that Heatwave is liable to my clients in contract and tort. So that's put in issue. And then equally, and perhaps more significantly, the second section of the defence, beginning at paragraph 27, pleads various clauses of the insurance policy which the defendants rely upon for the purpose of asserting that even if a declaration were to be granted under 22A, to the extent that Heatwave is liable to my clients for £40,000, even if that were established, nonetheless the policy wouldn't respond. And the reason for that is various conditions and particular exclusions are taken, and including, of course, the fact there is said to be an excess, which on any view would not form part of the recoverable sum due from the insurers under the policy. And one particular point if I may point out to you, we'll look at the policy in a moment, page 374, paragraph 31 pleads the certificate, and you'll see a little C on page 374, 31C. The certificate provided as follows, then 747, product service efficacy. The policy will not provide indemnity for any claim arising from failure of the product or service to perform its intended purpose. Now, my learned friends say that means that the entirety of my client's claim is not recoverable under the policy, and therefore, if it was to be recovered at all, it would have to be recovered in the liquidation by reference to whatever dividend, if any, it would be payable in the liquidation. There are other points that are taken. You can see at page 375, little C. It's also said that there are exclusions in clauses 17A and 17B.
We're not concerned with any of that, though, are you, Mr. Bailey?
I beg your pardon, my lord.
We're not concerned with any of that, though,
Well,
are we?
my lord, what we are concerned, or will be concerned with, is the fact that at the time the proceedings were issued, as is now clear, there was no certainty that my clients had a claim that was recoverable under the insurance policy. That's the relevant point, but I'll explain when I come to my core submissions how that fits in. What it means, my lord, is this, that at the time one postulates the claim under section 22A against Heatwave and has to consider the question, well, is that claim one within or without the liquidation? When you come to consider that point, it is relevant, we would submit, not only the fact there's an excess, which means on any view that part of my client's claim necessarily would fall within the liquidation, but also it's relevant to the fact that there is a dispute as to whether the policy responds at all. So at the time the proceedings would have been issued against Heatwave Heatwave's liquidator, my clients basically had a mixed claim for insured and uninsured losses, and it was unclear or uncertain as to what extent the loss would be uninsured. And that, we submit, is one of the reasons why it can't be said that the claim is outside the liquidation. So I've jumped ahead to an argument I'm going to make in due course, but that, I hope that answers my Lord the Chancellor's questions, why I'm showing it to you. I don't want to take much more time about it. That's it, really, as far as the defence is concerned. I would, if I may, though, very briefly take you to the policy itself. Policy is actually, it's the only other document we need to look at in the supplemental bundle, the Siddique supplemental bundle.
Yeah.
So it begins at page, it's tab 1, it begins at page 4. If we just very briefly look at this, the liability renewal certificate begins at page 5, and you'll see the insurer is described there as International Insurance Company of Hanover Limited. And as I say, I don't believe this is disputed. That company changed its name to HDI Global Specialty SE on the 1st of January 2019. The premiums there set out. Over the page, you have the limits of limits of indemnity. And this is also potentially relevant, certainly conceptually. Whether it would matter on the facts of this case is uncertain. It depends how many claims there would be under this policy. But what we do see is that in terms of products liability, which is a section of the policy my learned friends say, if any section of the policy responds at all, it's the products liability section. There's a limit, not only for any one occurrence, but in the period of insurance. In other words, there's an annual aggregate limit of £5 million, which may or may not be exhausted, depending on the number and priority of claims that are ultimately proved. So that could be relevant. And then, of course, there is the excess, which is set out under excesses, third-party property damage and bodily injury excess, £500. So that, on any view, would not be, or would have to establish the liability of the insurers, that 500, the bottom 500, whatever liability was established, would not fall for recovery under the insurance policy. Over the page, at page 7, you can see the endorsement, sorry, the exclusion, well, it is an endorsement, but it's endorsement 747, which operates as an exclusion. In the middle of the page, which I've already read out, so I'm going to read it again, but it's there on that page. And then there are standard clauses, which are not surprised to this court. The exclusions, for example, in relation to the product liability section are set out at page 16 and 17 under section C. The section doesn't cover damage for liability for damage to any product or any part thereof, so it wouldn't cover any liability for damage to the CWI itself.
Where are you reading from? Mr.
I'm sorry, I beg your pardon, I'm reading from page 17.
Yeah.
Section C, exclusions. So these are the exclusions to the product liability section of the cover. And basically, the damage to products, liability for damage to any product or part thereof. That's a standard kind of exclusion, namely it's only damage to other property which was provided, which is covered. And little e is also relied upon by the defendants excluding liability. And then there is the point in paragraph 19 or clause 19 on page 20 of the bundle, which is the self-insured excess, which we've seen already from the certificate is quantified at £500, and it's described in 19A as being a self-insured excess. Underwriters shall only be liable for that part of each claim or series of such claims arising out of one originating cause under this insurance, including defence costs, which exceeds the amount of the self-insured excess stated in the schedule. The insured shall retain the self-insured excess for his own account and not insure it elsewhere. And then we see, as we would expect, this arises as the court will know in any event, but at little d on page 21 there is the provision that provides that the underwriter will become subrogated to all rights of recourse of the insured, that's Heatwave, in the event that a payment is made. It doesn't matter, but it could in other cases, but this policy expressly provided for the non-exclusive jurisdiction of the English courts, and that English law would apply as no arbitration agreement, which might, in other cases, have created other issues. Indeed, had there been an arbitration agreement in the contract between Heatwave and my clients, that would have potentially created considerable difficulties because it might have been required to arbitrate against the company in liquidation in any event. In other words, invoking the original two-stage Larnell approach, notwithstanding the 2010 Act. So that point.
Am I right? I've been through the pleadings. You've shown us that the insurers took the limitation defence that was open to the insured, both in contract and in tort. But of course, you also showed us the letter before action, in which Mr. Allen was saying that he was going to be able to rely on Section 14A. Was there a reply taking the 14A response to the limitation defence or not?
There wasn't, my lady, no.
Well, that's curious, isn't it?
Well, my lady, the reason I don't think it was taken is because I don't think the 14A 3-year additional period would actually assist, because it would have expired in any event before the pleadings were, before the claim was issued in 2020.
Oh, right, yes.
So I think essentially in terms of limitation, the case comes down to the question as to what effect, if any, the compulsory winding up order of the 4th of March 2019 had. And the reason that's the key issue is because we say that the effect of that is that it prevents the insured, namely Heatwave, from taking a limitation point, and that's relevant because that's the same cause of action that arises under declaration.
That's the argument, and that it turns entirely on whether the relevant limitation period is suspended at the date of the winding up order, isn't it?
Absolutely, that's the only point.
That's the point.
That is the key point, yes, and probably the only point.
Well, it's the main point we have to
The main point, yes. I think was
Just going back to the 14A point, can just I'm slightly puzzled by that. Why wouldn't a 14A extension have helped
because the period the extension gives is 3 years
from
the date of knowledge.
the date of knowledge? And what's the date of knowledge? 2015, is it?
Well, he was saying 2017,
Well,
which is why I was
2017.
puzzled.
But
If
it
he
still
was
expired
right
before
about-
the.
If he was right about the 1st of October 2017, he'd have been right up against the wire, but he issued in when, 2020?
Unfortunately, the 14th of October.
So you
Yeah,
mean
3
out of
days.
time.
Oh, I see. Right.
You mean 13 days out of time?
13
That's
days
your
out,
point.
yeah.
Yeah,
Yeah,
unfortunately.
I follow. Yeah, sorry.
Okay.
Sorry, I hadn't got the dates precisely to
Yeah.
apologise, but yes, it doesn't help us, unfortunately.
No, he's 13 days out.
We're just slightly out of time.
Yeah.
The opposite of the position in Larnell, where they did take the 14A point and they were 1 day in time.
Yeah.
Yeah.
But anyway, there we are. Yes, there wasn't a reply, my lady. But what there was, however, was an application for summary judgment. And I'm not sure we necessarily need to turn it up, but if I can give you the reference, that would help. It's in the supplemental bundle at page 104. There was then a cross application made by Mr. Allam, which was returnable at the same time as the summary judgment application. And that was to add Heatwave back into the proceedings if, on the hypothesis that, or if the court concluded that the claim as against the insurers was time barred. And we can see that it's in, I think, supplemental bundle, Siddique supplemental bundle. At tab 28, I believe. so it's tab 28 of the supplemental Siddique bundle at
Yeah.
page 112. And it's an application notice issued in the claim by Mr. Mohammed Alam. You can see that in the top right-hand corner, and the relief that's sought is set out in the box at paragraph 3. The claimant seeks an order under CPR 19 to add Heatwave to these proceedings as defendant in the event that the claim against their insurer is held to be statute barred.
Is there an explanation anywhere as to why they will delete it from the, by amendment?
My lord, there isn't. There is some evidence. The only evidence there is what I was about to show you, which is a witness statement from a Mr. Philip Haig, which is in the same bundle, the next tab.
Right.
Begins at page 116.
Yeah.
It just sets out the facts at paragraph 6 and 7. Proceedings were brought to court on the 14th of October and the claim form was issued on the 19th. The claim was brought against Heatwave as first defendant and their insurer, HDI, as second defendant. Before service of proceedings, the claim form was amended to remove Heatwave from the claim and to proceed solely against HDI. Now, there isn't any evidence as to what the reason for that is.
No.
And I don't know, but if one is to draw any inference at all, my submission, the appropriate inference would be that the claimants considered it wasn't necessary to have Heatwave as a party to the action in order to succeed, and given the amount of money at stake and the fact they may have to apply to for permission to proceed against Heatwave, that would save costs. So those are the inferences, but I have to say there is no evidence, and I don't know. So I'm drawing those inferences. The witness statement, however, which we've just looked at, does set out the claimant's case on limitation, and one looks particularly at paragraph 13, which we say correctly identifies the scope of section 2.4 of the 2010 Act, where it said the claimant will also contend that the defendant can only rely upon the same limitation defence which is available to Heatwave, so the claim against HDI is also not statute barred. That's going to be one of the key points I want to deal with when I come to my core submissions, but we say in essence that the insurer steps into the shoes of its insured, Heatwave, the insolvent insured, and it's in no better and no worse position than what Heatwave would have been in had Heatwave been sued itself. In other words, had proceedings been brought against Heatwave in liquidation. And that's obviously one of the key points we'll come on to. But paragraph 13 in my submission accurately sets out what the law is on section 2.4. And then there's reference in this section, goes from paragraphs 12 through to 21, reference to section 130 of the Insolvency Act, reference to 2.4, which we've just been looking at, reference to section 12. It's quite right, as the witness statement says in paragraph 19, that the scenario described in section 12 is not in fact applicable, but it is relevant in the sense, again, it emphasises the fact that the insurer is not entitled to take any limitation defence which wouldn't be available to the insured. And then paragraphs 20-21, in response to any suggestion that a claim against an insurer is a claim made outside the liquidation, that as such limitation will not have been paused, an argument which I do not accept, I say that firstly, this is not a line of defence which would have been available to the liquidated installer if a claim had been brought directly against them, and so it's not a defence which should be available to the defendant insurer, and reference made to section 2.4. Now that again is we submit is absolutely correct. It's one of my core submissions which I'll be advancing today. Secondly, the fact that there is an insurance policy excess means that this is a claim which is brought within the liquidation in any event. There is now produced to me a copy of the certificate and so on.
These are all points for argument, Mr. Bailey. Why are we looking at them in the witness statement? They're all going to be part of your core submission, so why are we looking at this?
Well, that's a fair criticism, sir, my lord, and let's not waste any more time on it.
Yeah. Okay. Right.
What happened after that was the hearing took place before District Judge Clarke, and you know that what the outcome of that was, and you know that there was an appeal, and that came on before His Honour Judge Khan, and the judgment of His Honour Judge Khan, which I'm sure you may have read, but if not, I can give you the references in Core Bundle 1, tab 13 at page 100, and the order which is being appealed from is in Core Bundle 1. Perhaps I can just show you this, and then the grounds of appeal, so you have them in Core Bundle 1.
We finished with the supplemental bundle.
No, we put the supplemental bundle away now. I don't think we need to look at that again.
Cool bundle.
Take on board
Cool bundle 1.
or just Lewison's points. And
Tab.
the relevant order is at tab 12. This is actually this is the formal order that's being appealed from in this appeal, and you'll see that it records that the appeal from the judgment of District Judge Clarke was dismissed, and the judgment itself, His Honour Judge Khan, is at page 100.
Yeah.
And the grounds of appeal for this appeal are set out in the same bundle at page 18, behind tab 1.
Yeah.
And you'll see that it's a relatively concise, very short, only 3 sentences. Judge erred in finding that the proceedings against the insurer alone were not suspended by the insurance insolvency. The fact that the rights are not complete until liability of the insured is established, and furthermore by section 2.4, claims against the insurer alone are subject to the defences available in the hypothetical corresponding claim against the insured. So those are the key points. They're not extensive, but they are the key points on which we rely. And with that background in mind, I want to turn, if I can, to the second part of my submissions, which of course is the heart of my argument. And I have 4 core submissions to make. And the first of those is not controversial, but what may be controversial is what the effect of it is. And my first core submission is this, that under a liability policy, the insured's cause of action for an indemnity does not accrue and time does not begin to run unless or until the existence and extent of the assured's liability to a third party has been established by a judgment, an award, or an agreement. That's my core first proposition.
So repeat, under a liability.
Under a liability policy,
Cause of action
the
does not
assured's
accrue.
cause of action for an indemnity does not accrue and time does not begin to run unless or until the existence and extent of the assured's liability to a third party has been established by judgment, arbitral award, or agreement. Now, that's a basic proposition. The significance of it is what I'm about to deal with. First part of its significance is we know from a case called Post Office versus Norwich Union, which we can look at briefly, that the Court of Appeal in that case confirmed that this principle applied to claims sought to be brought under the 1930 Act. We have, I think, got a copy of Norwich Union in the bundles.
It was approved by the House of Lords in the Eagle Star case.
Yeah.
It's been approved in Eagle Star. It's also approved by the House of Lords in the Fanti Padre Island.
Yeah.
And as we'll see, it's
Under the 1930 Act, it was not a controversial proposition.
and Lord, as I'm about to say, it's never been a controversial proposition.
No.
Very briefly, and you're obviously on top of this, and I want to labour it. If I can just very briefly show you the way in which Lord Denning dealt with it, because fortunately, being Lord Denning, it's very, very concise, very easy to follow.
Authority bundle.
It's Norwich Post Office and Norwich Union. I believe it's at tab 24 of Authorities Bundle 1 or Authorities Bundle A. I don't know how yours have been marked. Are they A, B, C, D, or are they 1, 2, 3, 4?
1, 2, 3, 4.
Well, this is Authorities Bundle 1,
24 bundle 1, yeah.
tab 24,
Yeah.
Yeah.
Mm-hmm.
and the relevant section of Lord Denning's judgment is very concise. It begins at page 373, little e on the left-hand side. Reference is made to the transfer of rights and section 1 of the 1930 Act. And then he continues, under that section, the injured person, that's the third party. The injured person steps into the shoes of the wrongdoer, that's the insured. There are transferred to him the wrongdoer's rights against insurers under the contract. What are those rights? When do they arise? So far as the liability of the insured is concerned, there is no doubt that his liability to the injured person arises at the time of the accident. It's interesting, when negligence and damage coincide. But the rights of the insured person against the insurers do not arise at that time. The policy says that the company will indemnify the insured against all sums which the insured should become legally liable to pay in respect of loss or damage to property. It seems to me that the insured only acquires a right to sue for the money when his liability to the injured person has been established so as to give rise to a right of indemnity. His liability to the injured person must be ascertained and determined to exist either by judgment of the court or by an award in arbitration or by agreement. Until that's done, the right to an indemnity does not arise. And then he cites with approval a dictum from Mr. Justice Devlin in the famous Westway Price case. And he goes on under this section, it is clear to me that the injured person cannot sue the insurance company except in such circumstances as the insured himself could have sued the insurance company. The insured could only have sued for an indemnity when his liability to the third person was established and the amount of the loss ascertained. And he talks about the possibility for a declaration. But the key point is, but where the policy is admittedly good, the insured cannot sue for an indemnity until his own liability to the third person is ascertained. So that is effectively authority for the proposition which I advance as my first core submission. And what is the significance of that? Well, what it meant in the context of the 1930 Act was that the transferee of rights under Section 1 only acquired inchoate or conditional rights, which could only be enforced by action against the insurer once the existence and extent of the liability of the insolvent insured to the transferee had been established by judgment, award or agreement. So that's what the legal consequence was. And then the practical consequence. What's the practical consequence? Well, the practical consequence of this principle was that the third party had to sue the insolvent assured to judgment in order to establish liability and perfect its cause of action under the 1930 Act. Now, in the case of a compulsory winding up, permission is required from the court to pursue such a claim under what is now Section 130 of the Insolvency Act. But as Lord Justice Salmon said in the case we have open Post Office and Norwich Union, he said it's almost inconceivable that they would not obtain leave in the winding up to bring the action. And Lord Denning said at page 375 in the same authority at page 155 of the bundle.
No doubt leave would automatically be given.
My lady, exactly. That's the point I was going to make. And I'd also add here, and this is potentially significant because in my submission there should be no difference between the position of a creditor in a voluntary or a compulsory liquidation. But I should add, in the case of a voluntary winding up, i.e. a creditor's voluntary winding up, which was the position in Larnell, and of course could be the position in many other cases, the third party is at liberty to sue the insolvent insured in the ordinary way and doesn't need permission to bring that action. So, for example, in Larnell, no permission was required because it was a voluntary liquidation for the FCSS to bring the action against the insolvent company as a signee of the individuals who'd lost their money. That was the that was the practical consequence of the Norwich Union case. And what my learned friends say is, well, that sort of put a gloss, if you like. I think in their skeleton argument they say it put a gloss on the 1930 Act. Now, with respect, this doesn't particularly matter, but the principle that I've articulated as my core first proposition is in fact a fundamental principle of insurance law in my submission, that are very long standing. It can be traced back to 1839 at least, in a case called Collins and Haywood, which is discussed by the House of Lords in the Fanti.
Yeah.
And as we know, it was applied by Mr. Justice Devlin in the 1950s. And as my Lord Justice Lewison has already identified, it's been approved by the House of Lords in Bradley and Eagle Star, and also by the House of Lords again in the Fanti and at Padre Island. So why is that? What's the significance of that? Well, why is that relevant? It's relevant for this reason, that although it caused practical problems, as we've seen, in the sense one had to go off and start separate proceedings against the underlying insured, given the long-standing and fundamental nature of the principle itself, it is unsurprising in my submission that when we come to look at the 2010 Act, the principle of law that was applied by the Court of Appeal in Norwich Union and Post Office is both preserved and expressly given effect to. And just to make that submission good, I want, if I may briefly, just to take you to the 2010 Act, which is in Authorities Bundle. The current version that's in force as of today is in Authorities Bundle 4. At tab 66. I'm sorry, in a sense it's one of those Westlaw printouts, but it does have the possible advantage of being able to identify which bits are in force today and which bits were deleted and which bits came in at a later date. And that may be relevant when we look at section 6A, for example. But at the moment I want to...
It's incredibly impractical, you know, that the key statute should be at the very back of the fourth bundle of the authorities in a place where it's virtually inaccessible.
Yeah.
I apologise for that, my lady.
Why isn't it in the core? You know, this is the statute that we're all arguing about. It should be in the core bundle.
Yeah.
Sorry to whinge about it, but it is a bit irritating.
Yeah.
To have to go right to the back of a bundle to find the statute.
Well, my lady, I totally...
You're very lucky, Mr. Bailey, that your solicitors appear to have purchased extremely sturdy lever arch files, which contain way over the limit
Yes.
of 300 pages per bundle. I haven't yet suffered from bundle fatigue.
Well, I'm going to take mine out because inevitably mine will suffer from bundle fatigue at the end of
My
the
lady, perhaps we can all do that.
Well, anyway, Mr. Bailey, which section you want us to look at?
I just, before I deal with that, my lord, can I just apologise to my lady, please?
No,
I
it's
do
fine.
appreciate
Sorry,
Thank you.
points
sorry to
made.
sound off, but
Just so my lady knows what happened, there is a copy of the 2010 Act at the very beginning of the Authorities Bundle. Unfortunately, it was the copy that was enacted when in 2016. And what happened is this statute is a mess, as
Yes.
as my Lord the Chancellor knows from a case he was in. Lord Justice Bean gave a judgment explaining how
Yes.
the 2010 Act sort of got messed around with. But basically lots of sections have come in and gone out and been amended by various regulations. And the reason...
It's sort of lay dormant for the best part.
It's laid dormant for the history, in a sense, it's just peculiar. But the reason I'm mentioning it just very briefly is we did have a copy in the very beginning of the Authorities Bundle, but the parties decided, or one of the parties wanted to have the very latest version,
Right,
and it
okay.
came late, and it went at the end, and I can only apologise. I too, my lady, it's not the best place for it to be. And if everybody wants to move it, I'd be very happy to facilitate that.
Well, let's just look at it. shall
But
we?
anyway, if I may go back to the substance of the matter, the sections I had in mind are sections 1.3 and sections 12.4a. Now, so section 1.3, the third party may bring proceedings to enforce the rights against the insurer without having established the relevant person's liability. But the third party may not enforce those rights without having established that liability. So that, in a sense, both recognises, as we'll see, the ability to bring proceedings for declaration under section 2, but equally recognises the fact that the rights to enforce the claim for an indemnity cannot be exercised unless or until liability has been established, which is wholly consistent with the principle of law I articulated, which was applied in Norwich Union. And again, if we go on to
So section 1.3 seems to distinguish between bringing proceedings on the one hand and enforcing rights on the other.
Quite. Exactly, my lord, it does. As we'll see, you're entitled to bring proceedings, and we see that from section 2, even though you're not entitled to enforce any rights against the insurer until you've established the liability of the insolvent insured. And in terms of when the accrual of the cause of action against the insurers actually arises, it's clear, we would submit, if you look at section 12.4a, which is at page 1542. Where a person who has already established an insurer's liability to that person brings proceedings under the Act against the insurer, nothing in this Act is to be read as meaning that, for the purposes of the law of limitation in England and Wales, that person's cause of action against the insurer arose otherwise than at the time when that person established the liability of the insured. So what does that mean in practical terms? It means in practical terms that any claim for indemnity under the policy by the third party, the transferee, only accrues in the sense that time only begins to run once liability on the part of the insolvent insured to the third party has been established by judgment, award, or agreement. So what that means essentially is that once, if a third party brings a claim for a declaration against the insurer under section 2.2a, that the insolvent insured is liable to him for a specified amount of money, and obtains such a declaration, it's only at that point that the right then to claim an indemnity under the policy can accrue. And then, of course, that right itself is subject to determination as to any policy or coverage defences that may exist. So that's the analysis. But
Well, how does that fit with section 2.4?
Yeah.
Because the insurer can rely on policy defences in the action, that is to say, before the liability of the insured has been established.
my lord, no, with the greatest respect, section 2.4 is dealing with a very different.
I'm sorry, 2.3, I beg your pardon. 2.3. Subject to any defence on which the insurer may rely. So, if the consumer brings a claim against the supplier, the insurer can say in response to the claim, the supplier was guilty of a material non-disclosure, we're not liable.
Well, what can happen with this section 2.2b is what we're dealing with here. So we're dealing with a claim brought against the insurer for a declaration as to the insurer's potential liability to P. Yes, so we're only dealing with the potential liability of the insurer to the plaintiff, the third-party claimant. The reason it's called a potential liability is because obviously
Hasn't been
That hasn't
established.
been established.
quite, and it can't be established until that liability has been established either under 2.2a or by way of separate proceedings.
2.3 applies both to 2A and 2B.
Yeah. It's,
It's not just 2B, it's 2A as well.
That's a defence that an insurer can rely upon.
Yeah.
But that is a defence the insurer relies upon in the context of the coverage issues, the policy.
Well, whatever defence.
But the insurer can only have its own defence in relation to a cause of action which is brought against it. And the only cause of action that is brought against the insurer is a cause of action brought against the insurer under the policy. So the only limitation, or only defence that the insurer itself could have to a claim for an indemnity under the policy is a defence under the
policy
policy.
limitation defence.
Well, now that's very interesting, and of course that one of the practical benefits of 2.2b is that what can happen is that if there is a very short point on policy defences, then the way in which a case can be managed in court is that, for example, this case, for example, there could have been an application on the basis of, say, on endorsement 747. It could have, the court could say, well, let's take 747 as a preliminary issue. And the court could have said, well, even if you establish liability, Mr. Bailey or Mr. Allen, even if you establish liability and it's not time barred, and you then make a claim against the insurers pursuant to your transferred right, it's of no benefit to you because the policy doesn't respond. So that's
Surely the whole point, that's what Parliament's getting at, is to avoid the third-party claimant getting into a situation where he jumps through all the hoops that he had to under the 1930 Act, only to find that he's got an insolvent defendant who's not worth the powder and shot, and the insurer also doesn't respond under the insurance policy. So it's accelerating the process so you can find out in advance whether or not the insurer is going to be responding, or the policy is going to respond.
exactly.
That's the just looking at the bigger picture for a moment. That's what the aim is, isn't it?
Exactly. If I may say so, the overall strategy, if you like, of the new procedure was to enable the court more effectively to manage cases.
So if you look at it in practical terms, let's taking your point about 747. The third party brings a claim, brings proceedings against the insurer under section for declarations under 2.2a and b, establishes the liability of the installer for negligence, let's say, but the insurer is entitled to a defence under the 747 provision, and that would fall within section 2, subsection 3.
Yes.
That's the point, isn't it? But you do it all in one set of proceedings. Well, you don't. What doesn't happen is what used to happen. Was you go through the rigmarole of establishing liability, say by judgment against the installer in this case, who's not worth powder and shot because they're in liquidation, only to be faced when you then go against the insurer under the 1930 Act with a defence of a policy defence, relying on a policy provision or relying on non-disclosure or whatever.
Quite. Yes, little 3. In such proceedings, the plaintiff, or rather, that's the third party, is entitled, subject to any defence on which the insurer may rely, to a declaration under section 2a or 2b on proof of the insured's liability to P, or as the case may be, the insurer's potential liability to P. Now, the purpose, according to the Law Commission at least, of section 2.3, was to make the entitlement to declarations absolute and not discretionary.
To make it
absolute, not discretionary.
Yes.
Just to go back a second, I'm sure this is court knows this, but obviously a declaration in a sense is an equitable remedy, or possibly, but in any event it's thought that the power to make a declaration is a discretionary remedy, perhaps that's a better way of putting it, conceptually at least. And the purpose of section 2.3 was to ensure that there was no discretion, and providing you can satisfy
Hence the use of the words is entitled.
quite. But that was the purpose of 2.3. The key section that's relevant to this case is 2.4, because what we're concerned with at the present time is a situation where liability has not been established. There's no cause of action against the insurers under the policy that's accrued. What we're dealing with in the first instance is a claim for a declaration under section 2A, subsection 2A, and it's in that context that subsection 4 operates to allow the insurer to take any defence which the insured could have relied upon had the proceedings been brought against the insured himself. And the significance of that, we'll go back, when you look back at the defence which we looked at this morning, you'll see in the way in which the limitation point is pleaded that it's section 2.4 that is being relied upon by HDI, the insurers, for the purpose of asserting the limitation defence which the courts below accepted, was triggered and applied in this case. So it's section 2.4 with which we're concerned. But going back to where I was, if I may, we were dealing with the core submission about the fact that there is no cause of action against the insurers unless and until liability has been established, and the fact that that's reflected in section 1.3 and section 12.4 of the Act.
Yeah.
And that, in my submission, is not surprising given the fact it's a fundamental principle. Now, against that background, clearly it is necessary, a necessary and essential step, as it was under the 1930 Act, for the third party to establish the liability of the insolvent insured before he can enforce any rights against, apart from the procedural rights under section 2.2, any substantive rights, before he can enforce any substantive rights against the insurers, that he first must establish the liability of the insolvent insured. And section 1.4 of the Act, which we'll see at page 1530, identifies the various ways or mechanisms or procedures that the third party can invoke for the purpose of establishing the liability of the insolvent insured. And we can look at that, if we may, briefly at page 1530 of the authorities bundle, which is tab 66, section 1.4.
So what that does, Mr. Bailey, is it gives the injured party two routes. He can go down the old route and he can still pursue the insolvent company to judgment, yes?
Yes.
And then presumably go off and get his declaration if he wants it. Or he can short-circuit that process by going straight for a declaration under section 2.
My lady, that's right. May not necessarily be a shortcut, but certainly he has basically three ways of establishing liability. He can either begin arbitration proceedings, which he may be required to do in any event. For example, if there's an arbitration agreement in the contract between the third party and the insolvent insured,
Oh yes.
he may well want to take that route, which is the old-fashioned 1930 Act route. You may want to establish liability.
All right, so arbitration or court proceedings depending.
Arbitration or judgment.
Arbitration or judgment. In fact, you may want to choose arbitration because there may be no possibility for an appeal. It may be quick, it may be cheaper, depending on what rules apply and so on. And the significance of that, of course, we say is this: that if you're required to arbitrate against the insolvent insured, and you bring the claim in that
You're talking about an arbitration clause in the contract of insurance, not the contract between the consumer and
No, I'm talking about an arbitration clause in a contract between the
consumer and the insured.
insured. Exactly. Exactly. No, there are rules that deal with the situation where the arbitration clause is in the policy.
Yeah.
But they don't. It doesn't.
If you were looking at a case like the Fanti and the Padre Island, again, that would be the position, wouldn't it?
Yes.
Because the club rules required, the underlying contracts would be I can't remember what they were now, whether they were charter parties or bills of lading, but I think the bills of lading, they
Yeah.
may have had arbitration
Arbitration
clauses.
clauses, yeah.
Yes.
So you'd have had to arbitrate the claim against the insured
Quite. To establish the
to
liability,
establish the liability, unless you had an agreement.
which
some
may
sort
be
of settlement.
problematic. But this problem, if you like, or this issue, was addressed by both Professor Merkin and Lord Mance when they prepared memoranda. Now there may be an issue. I think my own friends say, "Oh, I can't refer to this in the context of construction of the Act." Now, I accept that, but what I'm showing you is not evidence they gave in the sense of oral evidence in proceeding. I'm showing you memoranda they produced for the benefit, which in my submission are no different to legal articles such as Jonathan Mance's article on insolvency at sea, for example, which is available to look at. And it's only for that reason I want to show you what Professor Merkin and Jonathan Mance said about this point in relation to arbitration agreements in the contract between the third party and the insolvent insured who caused the harm. And it's in the same bundle, maybe luckily. So we just need to go back a bit in bundle 4 of the authorities to, I think it's at tab 57.
Well, let's look at it. We'll look at it any essay anyway.
Well, I'm obliged. It's a memorandum that
rather than having an argument about it now.
that Professor Merkin prepared.
Where is it? What
It
page?
begins at page 1262.
12.
1262.
Oh yeah.
And this is paragraph 6.6. He deals with the consequence of an arbitration agreement, and obviously the fact an arbitration agreement may prevent a third party from joining the insured pursuant to clauses 2.9 and clause 2.10.
Sorry, what?
Paragraph 6.6 of the memorandum.
6.6.
Clause 2.29 that's of the 2010 Act, provides that the insured can be made a defendant to the proceedings, which may have procedural advantages. Joinder may also bind the insured of their as joinder, which may be useful if the declaration relates to the insured's liability to P, but there is loss out with the policy. So this is the point about, well, you can join under section 2, you can join the insolvent insured as a party under section 2.9, and then if you establish liability, by that judgment it binds the liquidator. So you have effectively killed two birds with one stone. That's the point. And he's making, Professor Merkin goes on to say that may not be possible when there is an arbitration agreement in the contract between the third party and the insolvent insured. And I think John Mance comes back to that, says it's one of those situations where you may end up having to have, in any event, parallel proceedings. Actually, my lady, you're on to the point, it's page 1289, little 4 of this is again not his oral evidence, it's a memorandum he produced, which my submission is the same status as his articles. Jonathan Mance says at top of the page, arbitration for the bill is also obscure and could usefully be clarified in its treatment of arbitration. If the third party's claim against the insured is subject to an arbitration agreement, so that's what we're dealing with, the claim against the insured, is that overridden by clause 2.9 entitling the third party to join the insured as a defendant in court proceedings under suit 2? And maybe not, and maybe parallel proceedings remain unavoidable in such a case. So going back to my lady's point, yes, the provision in the statute provides that liability can be established in 3 ways. Either by route of the old route, which is preserved, namely the route that was taken in Larnell. You issue either with permission if it's a compulsory liquidation or without if it's voluntary proceedings against the liquidator, as happened in Larnell. That's one route. Or you can, if necessary, arbitrate against the liquidator if there's an arbitration agreement. Or you can use the procedure, the new procedure introduced by the 2010 Act, which enables you to claim a declaration as to the insolvent insured's liability to you from the defendant insurer. But the key point in all of those procedures is that the cause of action that is being considered is the claim by the third party against the insolvent insured who caused the damage. That's the cause of action. And in my submissions, I'll go on to submit whichever procedure is used, then whether that cause of action is time barred or not, the answer ought to be the same in my respectful submission. But I'll come on to develop why that is so. That's one of my key points. I also just want to make these 2 points in this context.
Just so I understand that point, Mr. Davies, what you submit is this, is it, that where you seek a declaration under section 2(a) as to a declaration against the insurer.
Yes, it's a declaration against the insurer.
The cause of action is a cause of action against the insured.
Exactly, exactly.
Because it's a claim as to the insured's liability to you.
Exactly, my lady.
So in order to prove that liability, you've got to prove the ingredients of that cause of action and that he hasn't got a viable defence to it. And you do that in any of those.
Exactly, the same question
It's
arises.
exactly the same question in all scenarios.
Exactly, that's exactly my point. There are 3 mechanisms for proving, they're all procedural mechanisms for proving the same thing, the liability of the insolvent insured to the third party. That is the same cause of action. When we can look at Mr. Justice Blackburn's decision in the Eurocrit case, but my own friends for FSCS has developed this point themselves. When you look at a claim for a declaration, in terms of limitation, it's the basis of the claim, the underlying cause of action, in respect of which a question of time bar arises. There is another point which I'm going to develop later in my argument about specialties, if I may, which is a very interesting point. But the key question in terms of what the substantive rights are in relation to the 2(a) route or the arbitration route or the claim against the insolvent insured directly route is it's the same cause of action, and therefore...
So let's postulate a contract between the third party and the insured, which contains an arbitration clause, but it requires notice of claims to be given within a particular period. And the notice is not given within that period. Your point is that even if the third party were to bring a claim for a declaration under section 2(a), the time bar, the contractual time bar, would be imported into that act. So the answer would remain the same. Is that right?
Yes, because that's because of section 2(4), because section 2(4) requires the court or whoever is dealing with the matter to postulate this hypothetical scenario of what would the position
What other
be.
defences are available?
Exactly. In other words, the insurer, as I'm going to put it, steps into the shoes of the insolvent insured for the purpose of the section 2(a) inquiry. He can have no better, but no worse rights or defences than the insured would have if they were sued under under the old provisions which are preserved by the 2010 Act. And I mean, the key point is, what I'm trying to make is, the 2010 Act didn't come along and say, oh right, we're getting rid of the old way of doing things, and now we're going to have something completely new and completely different, and you've got to go and do 2(a), and you can't use the old mechanism anymore. It didn't do that. And in fact, actually, the Law Commission went out of their way to explain that's what they weren't doing, and this is one of the documents I'm entitled to show you. I don't think there's any doubt about it. It's clear authority that the Law Commission reports are relevant to proper understanding and indeed construction of the Act. And we have the Law Commission report. Forgive me if I'm going a little hoarse.
Yeah.
Sorry, my lord. If I could take you to the Law Commission report.
Where's that?
It's in the same bundle at tab 56. And I want to make 2 points, basically. First is it's a procedural right. Secondly, you have a free choice. But just to make those good, if we could go to page, begins at page 1091. And what I want to show you is paragraph 3.22 at page 1127. So 3.22, mechanism of transfer. Like the 1930 Act, the draft bill confers rights on the third party by effecting a transfer of the insured's rights under the insurance contract in respect of the insured's liability to him. The draft bill does not create new substantive rights. Instead, it transfers pre-existing contractual rights agreed between the insured and the insurer. It does, however, give the third party a new procedural right to the declarations set out below. So that sentence there, when it's talking about the new procedural right to declarations, that's a reference to what is in fact now section 228, 22b. And then we come on to 325, sorry, paragraph 3.25 at the bottom, page 1128. The third party's rights before liability is established. The draft bill differs from the 1930 Act by providing that the third party may issue proceedings against the insurer without having first established the liability of the insured. The draft bill does this by giving the third party a procedural right, which arises at the same time as the transfer of rights, to ask the court or tribunal for declarations as to the insured's liability to him and as to the insurer's potential liability to him under the insurance contract. And of course the word potential is used in the Act because of course it's only potential if and insofar as liability is established. But the key point I want to make is
Well,
that it's
the way,
procedural.
I mean, the thinking presumably was that if, I mean, leave the limitation to one side for a moment. If the third party brings a claim against the insurer under 22A and B for declarations and gets those declarations, then even though it's only a potential liability, the reality is that the insurer will almost certainly pay the third party's claim because there isn't any defence to rely upon because he will presumably have tried to raise the defence in the action and failed.
My lord, that's right, and of course it may well be that.
So in other words, the potential, although it does say potential liability, at the end of the day, if you get judgment for those declarations in the real world, that's going to be it.
Yes, and
Subject to an appeal.
Subject to appeal. But the reason it could work that way, in fact, if I may put it this way, is, for example, you're entitled just to seek a declaration under 22B. You don't have to seek a declaration under 22A. You could just seek a declaration under 22B, which deals with the policy coverage issues. And you can also, if you had to, bring an arbitration or bring court proceedings against the insolvent insured to establish their liability. And then you've got the two pieces of the jigsaw, if you like.
You can envisage cases where if in pre-action correspondence, the insurer's made it clear there's no issue about the liability of the insured to the third party. The issue in the case is an issue about policy coverage.
Right, in which case one could bring proceedings under 228 or 22B and resolve that issue.
Yeah.
And that would bring the dispute to an end.
Yeah.
Obviously, limitation issues would arise.
And that's precisely what paragraph 3.34 of the Law Commission report says.
3.34.
Yeah.
Yes, on page 1131. Quite.
Yeah.
Quite. And then the last sentence of that is quite significant. If the third party follows this course, then to the extent that he is unable to recover from the insurer, he will be able to enforce the judgment against the insured without the need to take further proceedings. And that, of course, means that they can go on to prove in the insolvency in the event that they can't recover under the insurance. But we have a bizarre situation here where what was happened is the courts below have said, well, claim against the insolvent insured is time barred, even though it's brought in time for the purpose of the liquidation. And yet, if we don't recover under the insurance policy, we can't presumably now recover in the liquidation because the claim's time barred. My own friends come up with a solution which means that somehow part of our claim is time barred and part isn't. As we'll see, Professor Merkin in the very recent section in Collinville and Merkin that discusses this case and explains some of the difficulties with the decisions that are being made below, demonstrates that if it's right, if Rashid and Siddique are right, it means basically a claim can one day it's time barred one day, and then subsequently it suddenly becomes untime barred. Now, for reasons I'm going to develop, that in my submission is heretical and fallacious, if that's right, and one of the reasons why the decisions below are wrong. I mean, I can show you that now. The reason it's not been referred to in the skeletons is because it's only the most recent update, if you like, of the Merkin-Collinville insurance text that has dealt with Rashid, because obviously it's only a decision last year, but we do have it in the bundle, so I think it's in the same bundle we're looking at. In fact, it's good that we're very pleased we're able to stay in the same bundle. It's in tab 59 of the same bundle.
That's 59.
And the relevant section is page 1374 to 1375. As I say, this is the very, very latest edition of Merkin. It came out after the skeleton arguments were
2023.
served.
Yeah.
Served in this appeal. And I'm not going to read it all out now, but I'm going to take you in due course to some of the passages. It's the heading beginning 6th. There's the Larnell scenario, whereby the insured has become insolvent and proceedings are not commenced against the insurers until after. Then he deals with that, and next paragraph talks about if it's necessary in analysing the correctness of Rashid. There is an important point I'll be showing you in due course to talk one of my arguments at the bottom of this page, where he talks about it being utterly bizarre. Utterly bizarre.
Where does he say that?
He says that at the
I've got it. About
four
lines from
the bottom.
It's utterly bizarre.
The entire purpose of the 2010 Act was to provide a more efficient mechanism for making of a claim against insurers for the policy monies. It would be utterly bizarre for a court to impose an additional limitation hurdle to the operation of that mechanism. Well, anyway, I'm going to make my submissions, but that's what the editors of this respected treatise on insurance say. And then the point I was making that tempted me to come here early was at 1375 in the penultimate paragraph, where it says in the third sentence, if Rashid is correct, it would mean that the third party's claim against the insured is time barred until the court determines that the insurance policy does not respond, at which point it becomes free of the time bar. Anyway,
How does that work?
Well, it
That's
doesn't.
on the hypothesis that if the policy doesn't respond, the third party still has a claim against the insurer
In the limitation.
it must be a claim in the insolvency. It must be
in the
liquidation.
insolvency.
Yeah. In which case, rolling stock applies and so on.
Yeah, okay.
But this is the problem that Larnell dealt with. When you have an uncertain situation at the time the claim is made against the insolvent insured, you have to treat it as if it's a claim in the liquidation, or at least you can't establish with certainty it's a claim outside the liquidation, and for that reason, the rolling stock principle applies.
Isn't underlying this point, isn't there an assumption, which I'm not sure is correct, that the effect of the Limitation Act is to take away a right, to remove the substantive right? But that's not what the Limitation Act does. It is procedural. And rolling stock, general rolling stock, is procedural. Limitation has to be pleaded, for instance. So if you sue a defendant and there is a potential Limitation Act defence in play and it's not pleaded, no limitation problem arises. So where is the bizarreness of an insurer taking a Limitation Act point, which he's entitled to do, let's suppose, because that's what we're arguing about, Limitation Act point succeeding, and then the third party going off to the liquidation of the insured and logging the proof, which is a different procedural mechanism for enforcing the underlying substantive right, which has not been taken away by the operation of the Limitation Act.
Well, the reason is because the insurer would only be able to take the limitation point as a defence if it was available to the...
Well, that's a different point, but what Professor Merkin is addressing in the passage you just showed us is what he obviously thinks is an utterly bizarre situation of a claim which is time barred in proceedings not being time barred in a liquidation. Now, my question is, why is that bizarre? Since they are two different ways of enforcing an underlying liability, whether it's tortious or contractual, which has not been removed by the Limitation Act.
My lord, I see that. I think the answer, or a answer if I may put it this way, is to suggest that the hypothesis that Professor Merkin has in mind is you imagine that all three procedures are simultaneously being invoked, let's imagine, hypothetically, and that the limitation point is pleaded in all three. Now, the point that Professor Merkin is making, or at least the point I'll be making, whether or not this is precisely the way he puts it, the point that I will be making is that when you are dealing with the same cause of action, which is the claim by the third party against the party that caused his damage in three different procedural scenarios, and I take your point about the pleading, but for the purpose of this hypothesis, all defendants in three separate procedures, the defendant in the arbitration, the defendant in the liquidation, and the defendant insurer in the section 22A proceedings, all plead the same limitation defence. In my respectful submission, it would be utterly bizarre if that limitation defence succeeded in one procedural scenario and not another. And I think that, if I may say so, is probably what Professor Merkin is referring to. But if I may, I'm going to come back to that. I'm sorry I got distracted slightly, but it is something, it's not in the skeleton, so you may not have seen it.
No, am I saying so? It's your strongest point, is that if you've gone down the old route, then this court will be bound by law.
Well, quite. Well,
And so I think it is the point that Professor Merkin's making, which is what on earth is happening if you use this new sort of shortcut mechanism, but you end up with a
worse
completely
result.
different
Quite.
result, which means that the claim's time barred.
Quite. Well, absolutely. That's one of my key points. But I don't even need to sort of... There's a shorter answer, if I may say. I do think that's a very strong point. I'm not disagreeing with my lord. It is a very strong point. But there's another strong point, if I may say so, which is this, that Section 2.4 actually requires the court to essentially imagine the Larnell scenario. And
You just look at the language of Section 2.4. The language of Section 2.4 envisages basically that the insurer is fighting the insured's corner, if I can use the vernacular, stepping into the shoes of the insurer to defend the action. And looking at it very simplistically, which I'm afraid I'm a simple soul, just sort of looking at it very simplistically, you say to yourself commercially, what's Parliament intending here? Parliament is surely not intending that the insurer should have a better chance of fending off the liability than the insurer himself.
why?
Or putting it in the negative, if the insured wouldn't have had a limitation defence because of general rolling stock, why should the insurer?
Have one.
Exactly. Exactly. That is exactly my case.
Is that point in any way affected by Section 2, subsection 5?
Section 12.1, yeah.
Well, in my submission, no. 12.1 is dealing with a situation where the proceedings have been brought against the insured, and time runs out before the relevant event occurs.
Yes, I mean 12.1 is contemplating the position, as you say, where there is an action in play against the insured at the time when the insured goes bust, and what subsection 1 does, it applies subsection 2. In the scenario in subsection 1, the insurer can't rely on the expiry period as a defence unless the insured is able to
Quite,
rely in the action.
quite.
Well, but if we are not in that scenario, what is it that prevents the insurer from relying on a limitation defence? Because section 2.4 is expressly made subject to 12.1.
Yeah, but because 12.1, what 12.1 is doing is it's postulating this scenario. The proceedings are brought in time against the insured, but the limitation period has expired before the insured becomes insolvent and a transfer under section 1 of the 2010 Act occurs. And what would be the position then? Well, the position then is that if you sought to bring new proceedings against the insurers under section 2.2a, the rolling stock principle couldn't apply.
Yes.
And the reason it couldn't apply is because the period of limitation had expired before the date of the voluntary, or the date of the insolvency, date of the winding up. So what section 12.1 and 2 are doing, if I may respectfully say so, is actually reinforcing the very point that my Lady Sandra just made, which is what the statute is trying to achieve, is to put the insurer in no better position than what the insured would be in. And that's hardly surprising. We're talking about the same cause of action. The claim by my clients against the party that caused me loss and damage. Why should an insurer have a better defence to that than the party that caused the damage would have? Conceptually, it makes no sense. Commercially, if I may respectfully say so, it would be bizarre. The fact, sorry, I mean, my fault slightly, but I just want to make one other point on the procedures that are available.
So 12.1 is contemplating, is it? And I found this very difficult to.
Yeah.
Maybe it's just me, but I thought it wasn't very well drafted. 12.1 is contemplating. It's contemplating a claim for a declaration against the insurer under 2.2a, or 2.2 generally, where there are proceedings already on foot against the insured.
Yes.
Which were commenced within time,
Yes.
but that limitation period has now expired during the period of those proceedings against the insured.
And
what
then
this is saying is the insurer can't rely upon any limitation defence that wouldn't have been available to the insured. And by definition, there isn't one available to the insured if the proceedings were commenced in time.
yes, but there would be, without this section, there would be a limitation defence in favour of the insurer, because he could say, oh, well, you're bringing me in as a new party, and therefore,
I follow.
Or even worse,
Yeah.
the insurer would be saying you're bringing a claim which is theoretically in relation to the insured's liability, and the insured's liability arose 12 years ago, notwithstanding that you brought a claim against him 6 years ago,
Yeah.
and therefore that claim is time barred. And so Parliament is saying, no, insurer, you can't do that. A claim's been brought in time and you can't take advantage of the fact that the claim against you, which relates to his liability, is late. I see that as actually reinforcing your case.
if I may say so, that was the point I was struggling to
So
make.
in other words, subsection 2, subsection 5 is simply making the point that the one defence the insurer can't rely upon is a limitation defence which wouldn't have been open to the insured,
Quite,
which is why it's subject to.
quite. And it does specifically refer to section 2.2a in 12.1. There is actually a passage in the Law Commission report which explains this. If I'm struggling, forgive me for a moment to find it.
Okay, right, where are we going now? Law Commission.
We're going to the Law Commission report. I'm just going to try and find the
the passage that deals with,
Page 1166.
thank you very much, 166.
1,066.
So it's paragraph 5.55, the last sentence. Under the draft bill, if a third party attempts to establish the insured's liability to him, the insurer will, in general, be able to rely on any limitation defence the insured could have relied upon. So that's the 224 point.
Yeah.
And then it says, however, it's been necessary to make an exception to this general rule. A third party who is already involved in litigation against the insured when he receives a transfer of rights may wish to bring an action immediately against the insurer. As we have explained, if such a third party makes an application before the expiry of the limitation period governing the ongoing proceedings, it will be possible to join the insurer to the existing proceedings. But if that limitation period is expired, it will not be possible. It's one of our principal aims to ensure that a third party who receives a transfer of rights should be relieved of the requirement to obtain judgment against the insured before obtaining the rights to the insurer. We considered recommending that the CPR be altered. However, we concluded that it was wrong in principle to extend the circumstances in which a defendant could be joined after the end of the limitation period. The draft bill takes a different approach. It prohibits the insurer from relying upon a limitation defence if the third party has issued proceedings against the insured in time. Thus, the third party will be entitled to issue separate proceedings against the insurer. It's likely the court would consolidate. So basically, all that is consistent, we would submit, with the basic philosophy, which is the insurer is in no better and certainly no worse either, no worse position than the insurer. The other point I wanted to make on the bill, on the Law Commission report, if I may, is the fact that the Act envisages that the third party should have a free choice as to which of the procedures he wants to adopt. And we see that from paragraph 3.28, which is at tab 56, page 1129.
$3.28.
3.28, my lord, yes. So at the top of the
29.
So page 1129, paragraph 3.28, the mechanism, when it says this mechanism, what it's referring to there is the ability to bring the claims for declarations under section 22A. And it says the mechanism in the draft bill is optional. The third party receives a transfer of rights before the insured's liability is established is not obliged to use it. Remains open to the third party to sue the insured, and once liability is established, sue the insurer on the insurance contract. Third party may elect to do this as he's already involved in proceedings against the insured when he receives a transfer of rights.
Well, let's just look at this commercially for a minute. Suppose that the position is that if you go down the declaration route, the insurer can immediately jump on the bandwagon and say, limitation, you're out of court, right? But if you go down the other route, one or other of them, general rolling stock will suspend the limitation period and
Right.
you'll be able to bring the claim in time. No self-respecting party is going to want to go down the statutory route because they'll be facing a time bar, and it means that they've then got to jump through the other hurdles which are still open to them. So that defeats the parliamentary parliamentary scheme of cutting short that, because it's going to be a disinhibitor to going down the declaration route.
Well, Lady, exactly. I mean, that is the point we made in the very first
And
paragraph of our skeleton argument. But yes.
What's being made here in 328, if one looks at a complex case of where the nature of the dispute is such that there's already proceedings on foot, which raise a series of complex issues between the third party and the insured. And what this is contemplating, as I understand it, is that during the course of those proceedings, let's say 3 years into those proceedings, the insured, the defendant to those proceedings, goes into liquidation. Therefore, the third party now has the statutory transfer of the rights under the policy.
Yes.
And what this is doing is saying that when he then makes a claim for a declaration against the insurer as to the liability of the insured to him, the insurer can't rely upon the limitation defence that wouldn't have been open to the insured by definition, because the proceedings have been going on
Quite.
well within time for how many years it is.
Quite. Exactly. I mean, and the point about it being optional, clearly if you spend a lot of money and you're close to getting a judgment and then there is an insolvency event, if it's a voluntary insolvency, you can carry on anyway. Probably wouldn't even bother to consider it. If it's compulsory, you need to go to the court and get permission to carry on. But as Lord Denning said, one would expect that to be automatic in those circumstances. But there are other reasons why you might want to take the procedural route. The arbitration is the one I've obviously discussed, and that's obvious. But the other bizarre scenario is that if this appeal fails, I think this is a point that prompted FSCS to become involved. If this appeal fails, what it means is that a key part of the whole rationale for the 2010 Act falls away. And what we're left with is a new scenario whereby, in order to benefit from the Larnell and the rolling stock principle, rather than using the streamlined method under Section 22A, which has, one would have thought, many other advantages to commend it, a party such as my clients, or many of the clients that FSCS has to act for, may well have to start proceedings in the old-fashioned way against the insolvent insured. And that's a very, we would respectfully submit, very surprising result indeed. In terms of it being optional, it's
You
not
thought there was a limitation, a period of limitation that might be going to expire in the near future. On the basis of this decision of Judge Khan, you would certainly go down the old route, wouldn't you? Is that where you'd know for sure that you weren't going to be faced with the defence which these insurers have succeeded in establishing before the judge?
But that may be right, but we'd be an odd situation where solicitors and parties would have to make the decision.
I'm not saying it's not. I'm not
no,
saying
no,
it's.
no, but that's
I'm simply making the point that that's a prudent third party would go down the old route.
It
That would be
drive
the-
you to it,
that
actually.
would they'd have no choice, but it'd
So
be
if they were
very
being
odd.
properly advised,
Quite
they'd go down the old route, because the old route doesn't lead to
limitation problems.
limitation problems.
But what I'm suggesting is that that is the solution. But it is, if that's right, it's just a very surprising one, because it would defeat what was thought to be the purpose of 22A in the first place, of providing a streamlined method for reaching the same result. But on the optional point, just to finish up on this, I think there's something in the explanatory notes that also deals with this, and that's in the first volume, I'm sorry to say, of the authorities. It's in bundle authorities bundle 1 at tab 13, I believe. So this is the explanatory note, yes, so page 56, explanatory notes to the Act. Now this is obviously relevant, and
Sorry, which tab?
tab 13, my lord?
Tab 30.
13,
13,
sorry.
What I've got is the one page of the commencement order.
Yes.
We got it at the back of the new printout of the Act which you gave us. Explanatory notes starts on page 1564.
Oh, that's helpful.
What is page 56, if I may ask, of your
Page 56.
page 56? Of authority
Tab
bundle.
12 in my bundle.
That's tab 12, that's the explanatory notes.
Ah, I beg your
Tab
pardon.
12. Tab 12.
I see, yes.
Okay, yeah.
My fault. I actually,
Same thing.
my bundle had the same problem actually. I moved the tabs and I forgot to mention that to anybody else. But yes, the tabs were wrong, but the page is right. It's page 56,
Page 56.
yes.
So explanatory notes to the 2010 Act.
Are they the same as the explanatory notes that my lord identified at 1564?
Fair question, my lady. Let me,
I think they are.
There are a number of explanatory notes relating to this piece of legislation, partly because there's been so many sets of regulations and other pieces of legislation that had to be mixed in. I haven't checked. I will, if over the short adjournment, I'll check. If there are any differences, I'll obviously point them out after the short adjournment. Paragraphs 4 to 6, it's all very familiar territory. I'm not going to take time reading it up. Just sets out the background and why the new mechanism was introduced. And summary of the reforms at paragraph 7, the first one being the third party cannot issue proceedings against the insurer without first establishing the existence and amount of liability. This may involve expensive and time-consuming legal proceedings. The Act removes the need for multiple proceedings by allowing the third party to issue proceedings directly against the insurer and resolve all issues, including the insurer's liability, within those proceedings.
I'm
Under
sorry,
the
Mr.
Act,
Bailey, which paragraph are you
I'm
reading
reading
from?
paragraph 7, my lord. It begins on page
Oh, yeah, okay.
56, goes over the page, just describing what is now
Yeah,
fairly familiar
okay.
territory, what the new mechanism is about.
As a choice.
And it's just the
isn't it?
last paragraph sentence I wanted to refer you to. Under the Act, the third party has the choice of using either the new method of single proceedings established by the Act or the existing method of first establishing the liability of the insured before initiating proceedings against the insurer. I mean, the whole, what I'm getting at here is that what the Act does is expressly preserves the Larnell route, is the point I'm making. And it would be bizarre having done that and given the parties a free choice to make one option of something of a trap. Again, I'm not repeating what FSCS say, but I think that's how they describe it, because 22A becomes a trap to the unwary, at least, because he may find himself in a worse position than he would have been in had he sued the insolvent insured. And that, we would submit, very strange indeed. And in fact, not just strange, for reasons I'm trying to expand upon, wrong.
Say antithetic to Parliament's intention, which was to streamline the process and make it easier to recover against the insurer, and you end up with a situation where it makes it much harder to get recover against the insurer.
Quite.
You go down the Larnell route, you establish liability, and then you fight your battle against the insurer in the old way.
Quite. My lady, what I'd like to do now, if I may, and I've covered perhaps all ground, and I thought I would have done my so-called core submission
Well,
one.
you
But-
said quite a while ago that it's your second part of your overall argument. You had 4 core submissions.
Yeah.
I'm not
Oh,
entirely
one.
sure that
No.
we've left one.
No, we haven't. We're still on one. And what I'm going to do is try and summarise where I've got to and try and make some key points in the hope that it brings it all together.
I'm just checking you weren't in free fall, Mr. Bailey.
Our fault, not yours, Mr. Bailey.
So trying to put it all together, what's the significance of my first core submission? That was basically that you need to establish liability first. And there were various procedures provided for under the Act, 2010 Act, that allow you to do that. And the first key point I want to make as a consequence of what we've been discussing so far on that issue is this: that whichever of the various procedures contemplated by section 1.4 that the third party invokes, namely the new declaratory route, the old Larnell route, or the arbitration route, whichever of those routes, procedural routes they adopt or choose to take, the substantive outcome, assuming limitation is an issue, ought to be the same. I would respectfully submit that that is conceptually sound as a matter of analysis and logic, but if support were needed for it, there is, in my respectful submission, some support for the conceptual point I've made in Larnell itself, in the judgment of Lord Justice Lloyd. And if I'd like to show it to you briefly, it's that we haven't looked at Larnell yet. It's in the second volume of Authorities, Bundle 2, tab 38. It's a point that Lord Justice Lloyd makes at paragraph 11 of his judgment. B38. And so this is an important case, begins at page 441 of the authorities bundle. The paragraph I have in mind for this particular point is paragraph 11 on page 446.
Yeah.
And what Lord Justice Lloyd does there, he says, it's clear and settled that the third party has to establish that the insured is liable to him before he can take advantage of the rights afforded to him under the 1930 Act. See Post Office and Bradley Eagle Star. Liability may be established by action, by arbitration, or by agreement between the insured and the third party. Now, of course, we can add in now two qualifications to what he said. First, you qualify the first sentence by saying he still has to establish the liability of the insured before he can take advantage of any substantive rights afforded by the 2010 Act. He's got new procedural rights, but the substantive rights still remain incoherent. And then the second sentence, where he says liability may be established by action, by arbitration, or by agreement between the insured and the third party, you have to add in there, or by declaratory relief pursuant to section 22A. Then he goes on and says the terms of the insurance policy may prohibit the insured from reaching any such agreement without the consent of the insurers, so the agreement may not be feasible in these situations for practical reasons. If proceedings are necessary, they may take one of a number of forms. The obvious instance is a claim such as the present. Because the company is involuntarily winding up, it is necessary to obtain consent before starting such a claim. If the winding up were compulsory, the court's permission would be needed, and the court might regard it as more appropriate for the third party to prove for its debt. If the liquidator were to reject the proof, the third party could appeal against that rejection under Rule 4.83 of the insolvency rules, and that would lead to a judicial determination, which would also be sufficient establishment of the liability of the insured. Nothing turns on the particular procedure adopted. It makes no difference whether the proceedings themselves are brought within the bankruptcy or winding up proceedings or outside them, as is the present claim. And what Lord Justice Lloyd is saying, if I may strictly say for, is that whichever procedural route you're dealing with, the key question, the key substantive question that affects the rights and obligations of the parties remains the same. And therefore, whichever procedural route the parties find themselves on shouldn't affect the answer to the substantive dispute between them. Now the second point, so the second key point I want to make, so that's the first, there's still key points arising out of the Norwich Union Principle. The second key point I want to make is this, that at the time that my clients commenced the claim in October 2020 against the respondent insurers under section 22A for a declaration, the right to an indemnity under the policy, albeit transferred under section 1 of the 2010 Act, remained an incoherent right and was entirely dependent upon both successfully establishing the liability of Heatwave, which was disputed by the insurers, and also defeating the insurers' coverage defences. So at the time the proceedings were commenced against the insurers, my clients had no entitlement to enforce any extant right against any assets outside of the liquidation. And that's important because it means that my client's position was and remains today totally different to that of a secured creditor because my clients had no accrued rights to enforce any claim against the proceeds of the policy. And that's because, as we've seen from section 1.4 of the 2010 Act, they had no right to enforce a claim against the policy proceeds unless or until, this is express language of the Act, unless or until the liability of Heatwave had been established. Now, we would respectfully submit that in itself, this point I've just articulated, putting rolling stock to one side, this point in itself is an answer to the appeal. And the reason for that is as follows. In October 2020, when the claim form was received by the court, which is the date by reference to which any question of limitation is to be decided, my client's rights to an indemnity under the 2010 Act were exactly the same as the claimant's rights to an indemnity under the 1930 Act in Larnell. In other words, in my respectful submission, the position of my clients is identical to the position of the claimants in Larnell. And what I want to show you is what Lord Justice Morbick said would be the consequence of that in Larnell, which we have open, I believe, at the moment. And it's paragraphs 61 to 63, which is pages 460 to 461 of the authorities bundle.
460.
460, it's paragraphs, I think to give it some context, probably begins with 61, where he says it's necessary to consider whether the claims brought against the company in the present case are claims within or outside the liquidation. Now why is that relevant? Well, that's relevant in a sense to the rolling stock inquiry, because the purpose of the rolling stock rule is that the duty of the liquidator is essentially to identify the debts that were due and owing as of the date of liquidation, and then the trust kicks in and they're compensated pari passu by reference to the assets of the company. And the significance of that is the fact that if the debt exists at the date of the insolvency, the date of the winding up order, then the practical effect of the rule is that limitation doesn't run thereafter. That's the practical effect of it. So to see whether rolling stock applies, one of the ways you can do that is ask yourself the question, well, is the claim brought within or outside of the liquidation? And that's the question that Lord Justice Morbick identifies at the beginning of paragraph 61. And then he says, the company says that they are claims outside the liquidation because the claimant is seeking to obtain the benefit of the rights under the insurance policy which do not form part of the company's property. The judge accepted, Mr. Justice David Steele accepted that argument. He held that although the underlying cause of action remained one against the company, the potential for recovery under the policy could nonetheless be treated as an asset outside the bankruptcy. So Mr. Justice Steele, basically what he did is, well, you don't have an accrued right under the policy, but you have a potential right, and that's enough to take it outside the liquidation. Incoherent right's enough. Lord Justice Morbick says, no, it's wrong. He says, with great respect to the judge, I think he was wrong about that. Although the 1930 Act operated to transfer the company's rights under the policy to the claimant at the commencement of the winding up, those rights were incoherent and entirely dependent upon the establishment of the company's liability to the claimant. Pausing there, well, that's true today in terms of the substantive rights transferred under the 2010 Act. You have new procedural rights that kick in immediately, but substantive rights to recovery under the insurance are totally dependent upon the prior establishment of the liability of the insured to the claimant. And he goes on to say, so in other words, the position is exactly the same under the 2010 Act. But Lord Justice Morbick goes on to say, until that liability has been established, neither the company nor the claimant has a right to recover under the policy. The position is unlike that of a secured creditor who has an immediate right to satisfy his claim by recourse to the security. In the present case, Lord Justice Lloyd has explained the claimant's rights against the company could be established by proceedings in the ordinary way, this being a voluntary liquidation, or by appeal against the refusal of the liquidator to admit its proof, but in either case, if it was successful, it would establish its right to prove in the liquidation. By so doing, it would also complete its cause of action against the insurers under the policy. But that does not mean that the claim is one that is being made outside the liquidation, or that the present proceedings are proceedings to enforce rights against property outside the liquidation. And this is the key sentence. They cannot be, since no such rights exist until the company's liability has been established. Well, we would respectfully submit that is equally applicable to the situation my clients are in when the claim form was issued, namely that they had no rights to any recovery under the policy unless or until the liability of Heatwave had been established.
What he goes on to say at 64, when he said, I find at the end there, he rejects Mr. Tolley's submissions and says, I find it impossible to accept the same claim can be time barred for one purpose but not for another.
Yes.
Either the claim can be brought or it cannot.
Yes.
I mean, you would say that by analogy at least, the same analysis should apply to whichever procedural route is adopted in order to enforce the relevant
Quite.
right.
I would say
It's
that.
the same claim.
I
which
would
is
say
the
that.
same
I
cause
don't
of
accept the purpose point is actually the right analysis. Indeed, when you look at Law Justice Lloyd, you'll see that he actually rejects it. And indeed, Mr. Tolley actually went on to accept that purpose isn't the right test. He used a result-based test. But putting that to one side, the point my Lord makes is exactly right. I do rely upon it in that sense. Because it cannot be that one cause of action, so a single cause of action against the same defendant, namely Heatwave, because that's the postulation that 2.4 requires us to consider, and it's the basis of the declaration under 2.2a in any event. It cannot be that that same cause of action against the same defendant for a, and this is also important, for a single loss, £48,000 or whatever it is. It's not like the separate causes of action for different elements of loss here. There's a single loss, which may or may not be uninsured or insured, we don't know. But in any event, there's an excess which is definitely uninsured. For all those reasons, whichever procedural route one goes down, then the substantive answer as to whether it's inside or outside the liquidation ought to be, in my respectful submission, the same.
Well, we know, I think, that under the 2010 Act, the third party is not entitled to enforce against the insured anything which is recoverable from the insurer. So let us suppose that the third party goes down the old Lionel route, lodges a proof with the liquidator for £48,000, whatever it is, and the liquidator says there is an excess of £500 on this policy. I will admit your proof for £500 and I will reject the rest. Now, how does general rolling stock fit into that scenario? Because general rolling stock, as I understand the principle, is that provable debts must be dealt with in the insolvency. And if a large part of the claim is not a provable debt, why should the general rolling stock principle apply to it at all?
Well, because we don't know at the time the proceedings are commenced whether it's a provable debt or not.
Well, we know, assuming that the policy is valid, that the provable debt cannot be, well, no, I suppose if the insurer's defences under the policy work, then the whole thing would be
Quite. No, the problem. It's not. The problem is we have a claim for £48,000.
You don't know which
We
way
don't
it's
know
going
how
to go.
much at the moment. How much is going to be recoverable under the policy or not? But we know that some isn't. Now that was a key point. So it's a mixed claim.
Well, the liquidator in the hypothetical situation that my lord has postulated, the liquidator is not going to say, I'm only going to admit 500 until the liquidator knows what the outcome is under the insurance policy. So he might say, well, I'll admit your claim for 500 and I'll provisionally admit your claim, or I'll park it in relation to the balance until we know exactly what happens on the insurance side. And you would hope that by the parallel route that's going on, that will all have been sorted out by the time you actually come to sort out the liquidation.
Quite. That's all right. But the one thing I'd add, which is the only point that really matters for the purpose of this appeal, is what the liquidator wouldn't do and couldn't do is say, sorry, I'm not admitting it at all because it's time barred. And I think the point that my Lord Justice Lewison was putting to me is, I think it came out of section 14, I think, if I remember.
Yeah.
And in that sense, there is a short passage, I think, that Professor Merkin and Colin Merkin address, which I ought to just show you. Again, I apologise that the Merkin wasn't in the skeletons, but it came out after the skeletons were drafted. It's in bundle 4 of the authorities.
Yeah. Back in bundle 4.
Bundle 4, and Merkin is at tab
59.
59, and it's at page 1375 of the bundle. Again, he's discussing Larnell and Rashid and rolling stock. And at the end of the previous paragraph, he said, there is nothing to prevent the assured from proving in the insolvency proceedings for the full amount of the assured's liability, and with the leave of the court obtaining judgment for that sum even after the expiry of the limitation period. He says at this point, the effect of section 14 must be borne in mind. Once the assured has become insolvent, the third party cannot recover from the assured any sum that is covered by the insurance. That makes it clear that the only sum that may be recovered in the liquidation is any uninsured sum. Any suggestion that section 14 thereby takes a claim for insured liabilities outside the liquidation disregards the basic principles underlying the 2010 Act. It remains necessary for the third party to establish and quantify the liability of the assured as the gateway to the insurance proceeds. All that section 14 does is to prevent enforcement of an insured liability in insolvency proceedings. It doesn't prevent the establishment of such liability within the insolvency proceedings. If the insured has been joined under section 2 and the judgment on the assured's liability has been obtained, that will happen automatically. If the assured is not joined to the section 2 proceedings, then there will have to be a proof in the insolvency. The point remains that the section 2 judgment against the insurers with or without the assured does not preclude a full claim against the assured in the insolvency proceedings. It's not to the point that section 130 requires the court's permission to claim against the company in liquidation. The question is whether there is a time bar that will prevent such a permission being granted, not whether the court would have given such permission. Once it's established that there is no time bar, and that's the rolling stock point, to establishing and quantifying the assured's liability, the condition precedent has been satisfied, and the Act confers a right upon the third party to proceed against the insurers to establish that liability. The point about section 14 is this, that if in due course a sum is recovered by my clients or indeed any third party from the insurer, then he is unable to enforce in the liquidation a claim for that recovered sum. And that's, again, a perfectly sensible conclusion, because it wouldn't, unless you get a full dividend, which is highly unlikely, that would be the only base you get double recovery, but you shouldn't get more recovery in the liquidation than you're entitled to in the insurance.
Yeah.
And enforce in section 14 means what?
Enforce means the ability to recover a share of the assets of the insolvent company that have been collected as part of the trust that the liquidator administers.
Well, it arises, doesn't it, where rights in respect of an insurer's liability to a third party are transferred under section 1. So this is on the hypothesis that the insured has become a relevant person. So in other words, simple case, the insured is in liquidation.
Yes.
The third party may enforce that liability against the insured only to the extent, etc. So that is postulating enforcement of the liability in the liquidation, because or in the whatever the procedure is,
Yes.
administration or whatever, because
Yes.
that's a context in which there's been a transfer under section 1.
Quite. I mean, what it's doing is recognising that mixed claims are likely to be, when I say mixed claims, what I mean by that is the sort of, I think the Lord Justice Lloyd sense, namely that there's a claim which consists of what may be partly uninsured and what may be partly insured losses. And what it's recognising is that to some extent such a loss or such a liability may end up being compensated in two ways, partially under the insurance contract and partially by way of a dividend in the insolvency.
The classic example being the excess, because it's virtually unheard of for an insurance not to have some form of excess.
Exactly, certainly a civil product or public liability policy, exactly. There are special rules in relation to compulsory personal injury,
Not
that's a
third
different,
party motor insurance.
different concept. In commercial such scenarios such as this, product liability policy, I haven't come across any without an excess. But, so it's certainly very common, let me put it that way. So, my lord, perhaps my optimism first thing this morning as to timing was a little bit overstated, but I'm now going to turn to my second call submission, if I may.
Have you just finished your first?
Yeah. But these will probably go much more quickly, I hope. In fact, I've alluded to a lot of these, so actually I've alluded to them. I'm now going to make them perhaps explicit.
Right.
So my second core submission is this, and it's really the section 2.4 point, and I say I've alluded to it. Perhaps I've done more than allude to it. But the second core submission is this: that when proceedings are brought for a declaration under section 2.2a, as to the liability of the insolvent insured, the basis of the action and the relevant cause of action for limitation purposes is my client's claim for damages against Heatwave, the company in liquidation. My submission, that's clear from sections 2.2a itself, and it's explicit in section 2.4, properly construed. And this is a point that the relevance of this is that the arguments below and the judges below seem to say, well, section 2.4 is permissive, and therefore the insurer has different and better defences than the insured, which is we submit completely wrong. The reason it's wrong is because section 2.4 makes it clear that it's only defences available to the insured that the insurer can take. And moreover, as a matter of conceptual analysis, and this is the point I'm about to make, if there is a claim by way of a procedural right to a declaration in relation to a cause of action, such as the liability of Heatwave to my clients, and that declaration is sought under a statute pursuant to a third party, such as the insurers, the basis of that action for the purpose of limitation remains the underlying cause of action itself. And I think this is common ground now, because I floated a point about specialties a week or so ago, and I want to come back to that because it's quite an interesting point. But what it prompted from my own friends is a skeleton argument which basically affirmed the primary point that was being made, which FSCS were making. And they did it by reference to a quite interesting case called Euroquit. And in fact, of the various cases, it's not one I don't think that my own friends, Mr. Lynch, has cited. So I don't feel I'm treading on his toes if I can take the court to it. So,
Yeah.
it's in bundle 4 of the authorities bundles. It's in the same one I think we're looking at.
Yeah.
So tab 64. Oh, sorry, that's wrong. Tab 65. And what this case, it was a decision of Mr. Justice Blackburn sitting in the Chancery Division in 2007, and it concerned an application being made under section 212 by the liquidator for a declaration that one of the directors whose misfeasance apparently caused some loss to the company should be required to compensate the company. And the question as to time bar arose, and one of the points that was being considered was, well, even if there was a time bar in relation to the company's claim that had expired, the right to a declaration that the liquidator could bring under section 212 was a new cause of action, new limitation period, and therefore, even though the claim the liquidator is seeking to enforce is essentially the same cause of action the company had, a new time bar applies. I hope that's a fair summary. I'm sure Justice Lewison will correct me if I've got the statutory process wrong, but I think that's what section 212 does. But the point I want to show your lordships is in paragraphs 24 to 25. And begins really by the first sentence of paragraph 24. In my judgment, Mr. Wilson's submissions, he was acting for the liquidator who was seeking to say this action was brought in time. On this point, do not pay sufficient regard to the significance of the fact made clear by the authorities that section 212 is procedural in nature. The true significance of that fact is that the section merely provides an alternative means in terms of procedure of enabling the company to which the defaulting director's duty was owed to obtain recompense from the director for his breach of duty. And then I'm not going to read it all out, but I would certainly suggest you do so. A little point I want to emphasise at H. In each case, however, the claimant is in substance the company. In other words, it's the company's cause of action that is being pursued by the liquidator. And then he says at the end of that page, this is so whether the claim is brought by the company or by the liquidator, or for that matter, by a creditor or a contributory. It would be extraordinary, therefore, if finding that a claim brought by the company in liquidation against a defaulting director had been successfully non-suited on limitation grounds, the company's liquidator could, in effect, ignore that result and advance the self-same claim again, but in his own name, shorn of any risk of a successful limitation defence, merely because the claim was brought within 6 years of the commencement of the liquidation. Pausing on the argument being that the right for the liquidator to bring the claim under section 212 only arose when the liquidation took place, and that's when 6 years kicked in. That was the argument. And then he says the reason he cannot is there is only a single cause of action, that of the company. All that section 212 does is give the liquidator, if he wishes, the right to bring the claim in his own name.
You say this is the reverse situation. There's one single defence. It's the defence of the company, and the fact that the insurer is taking it doesn't change the substance of the defence.
Absolutely, it's a two sides of the same coin point, if I may put it that way. And the other way of looking at it is, say, the last two sentences. It says, the reason that the insurer cannot take the different limitation defence is because it's only my clients only have a single cause of action against the insolvent company, and all that section 2122A does is give my clients, if he wishes, a different procedural right to claim that cause of action against the insurer directly. I mean, that's the scenario we're talking about. But the key point that matters here is that when you're looking at a claim by way of a declaration, that is procedural in nature, which is exactly what section 22A is. The basis of the claim, i.e. the cause of action that's being advanced, is the relevant consideration for the purpose of limitation. And the point that Mr. Justice Blackburn is making is, if that cause of action is time barred in one sense, it'd be surprising if it's not time barred in another. And as I say, two sides of the same coin. If it's not time barred in one situation, very surprised if it was time barred in another. In other words, the result ought to be the same in each situation.
Does that mean that you're not pursuing the point based on ZEDRA?
No, I've been trying how to spin these points together, because they don't, there is a tension between them, and I accept that. And in my skeleton argument, I did say, if the claim under section 22A is regarded as an independent cause of action, then it follows. And there is a point. Well, it's true to say, and I'm jumping ahead, but since your lordship's asked the point, and it is obviously in your mind, let me try and answer it as best I can now. It is the case that it always remains that the cause of action that's being considered in the context of section 22A is the claim against the insolvent insured. That's always going to be the cause of action. That's always the basis of the declaration. And therefore, prima facie, that should be the only limitation consideration that arises. And what Mr. Justice Blackburn does in the next paragraph 25, he says, well, if you look at Lord Justice Diplock's analysis of what amounts to a cause of action, what the necessary facts are that you need to establish in order to establish a cause of action, the fact that it's brought against in the name of a different party is not an element of the claim which creates a new or different cause of action. I think that's essentially what he's saying.
And that's what Matadine says as well.
Yes, indeed, what Matadine says. Now, the one peculiarity about section 22A is that there's not only a name change, in the sense that what 22A does is give a procedural right to bring a claim against a different party, named the insurer, in relation to the insured's liability. So not only a name change, but you could say, well, one essential one essential element you have to establish in order to bring an action under section 22A is that the insured has become a relevant person. And you could say, therefore, that actually, unusually, perhaps, section 22A is one of those scenarios whereby there could be said to be two limitation periods that are applicable. One for the purpose of commencing the claim for declaration in itself, which is the 22A specialty point, and one in relation to the underlying claim in relation to which the declaration is concerned, which is the rolling stock limitation issue in relation to the claim against the insured. And the reason you might say that is, well, because 22A is a peculiar provision. Not only does it involve bringing an action against a new party in relation to somebody else's liability, but also it requires you to prove that there has been an event which makes the insolvent insured a relevant person. And that's a necessary ingredient of the cause of action, which goes beyond the underlying cause of action against the insolvent insured himself. And therefore, you could say it's an action on a specialty for the reasons that were articulated by my Lord Justice Lewison recently in the Zedra case. That's the argument. But why am I running it? Well, it doesn't help. It doesn't help my own friends here. So it's not a point. It does them any good anyway, because clearly the section 22A claim by my clients is brought well within 6 years of, or 12 years of, the commencement of the winding up order. So it doesn't help. The relevance to the point is that I've made in relation to the specialty is this, that one of the points that my own friends make is, well, Bailey's case can't be right, because if it is, it's going to be terrible, because section 6A, which was introduced several years after the Act was formulated, meant that a dissolved company could be a relevant person, which means that if that dissolved company used to be a company liquidation and the rolling stock principle applies, that dissolved company forever and a day can be made subject to a claim under 22A, and we're faced with claims in perpetuity. That's the argument. And there's no long stop limitation act bar. So that's the argument. And it's in that context that I'm suggesting to this court that and I've got other answers obviously, but one of the answers I have is, well, one way of construing the Act to achieve its purpose and policy considerations, one of which must be limitation in relation to stale claims. I mean, my cited 5, 7 or 8 authorities with the same proposition in Zedra about stale claims, so it's clearly an issue. One possible way of resolving that would be to construe section 22A as having this slightly unusual, but for reasons I explained, not conceptually incoherent, independent life as a specialty, because you have to prove both the relevant person and the factors against a different person, 2 different features, to get into 22A at all. For that reason, it's to be treated as a specialty, and therefore there is a long stop, because there's 12 years, and if you don't bring your application, or sorry, your section 22A claim within 12 years of the liquidation, then you're too late. Oh, sorry, I say liquidation. That's technically, I should say, within 12 years of the party becoming a relevant person. Anyway, that's the point, my lord. So I'm not abandoning it. That's the space. It's a very long answer to a question, but I'm still keeping it in that sense.
But your primary case is that the
Doesn't matter.
section 22A route, it's the same course of action as
Yes.
the traditional
Yeah.
route, because it's the same course of action for breach of contract or tort or whatever it is,
Quite.
in
Quite.
respect to which one's seeking a declaration as to liability.
Quite. I'm not. In fact, they're not alternative cases. That is my case in any event.
Yeah.
This isn't whether there's an additional issue in relation to just the insurer. But yes, my lord, just put the point precisely as I seek to put it.
Well, that's a complete. If you're right about that, that's a complete answer in any event to the point about open-ended liability forever.
Yes.
Are you going to come back to dissolved companies? 'Cause I do have a couple of questions.
On section 6A and
yeah,
42.
I'd like to ask you about that. Maybe I could do it now, so everybody's got now to think about it.
Well, that's very kind. Yes.
Under section 6A, you don't have to restore the dissolved company.
That's right.
If you were to restore the dissolved company, then a limitation period would retrospectively be revived. But the court has power to make what is usually called a limitation direction, saying that a period from dissolution to some other date is not to count for purposes of limitation. But in order to get such a limitation direction, you need to satisfy the court that there was a causal link between the dissolution of the company and your failure to institute proceedings. If you go down the 2010 Act route without dissolving, without restoring the dissolved company, on the face of it, you seem to avoid that hurdle which ordinary company law would impose. I don't know quite how you fit that into the framework which you are. I'm not asking you
It's
to
a very
answer
interesting
on
point.
your feet, but
Very interesting point. I mean, I will reflect on it. Can I give you just a short answer that comes to me in my mind immediately? And of course, I will reflect on it. Probably, I may not get a better one, but this is what I've come up with so far. That's an oddity, if I may say so, a slightly anomalous point that your lordship's made. Section 6A is a very strange section. It was introduced, as I say, last minute almost. It already caused a number of problems and resulted in the Act having to be amended still further. But if what my lord has articulated is part of its effect, then what I would submit is it actually is illustrative of how far Parliament has gone in terms of trying to make the position of a party who has suffered a loss at the hands of a dissolved in the case of 6A or any other relevant person in the case of 2 and 4, easier for them to recover. I mean,
Because it is jolly difficult actually to get a limitation direction.
yeah.
I know, having granted one and been told for it, so yeah,
Yeah.
it is hard.
I mean, the other point, I know my Lord Justice Lewison told me he's got another one for me to worry about over lunch, but before he gets to that, there is one other point I wanted to make, which is this, which is an oddity, which is this, that if you can't, and this is one of the points I was going to make as to why you wouldn't have a claim in perpetuity if there was a 6A dissolution of a company that had been insolvent before and been dissolved at the end of the liquidation, is because if the insurer cannot restore, because the 6 years have expired, the dissolved company to the register, then he wouldn't have any rights in subrogation. And that can't be what Parliament intended, in my submission. It would be another anomalous result. If 6A is a perpetuity problem, it actually is a problem that's the result of the Act. In my respectful submission, 6A needs amending rather than reversing Larnell. I mean, actually, Professor Merkin, he seems to have covered a lot of the points that have your lordship's had in mind, but he actually deals with this point as well, if I remember rightly, in bundle 4 of the authorities. If I just find it before the shorter German, just show you this, since it's the point,
59.
perpetuity point, it's been raised. It's in tab 15, page, was it
59?
59? 59. It's a page, page 1375. And he does mention the 6A point. I think this is the point my own friends are seeking to make, actually. It's the last 2 sentences. It's also the case that under section 6A, the dissolved company is treated as a relevant person, so it remains possible to establish and quantify its liability in perpetuity. However, the prospect that this may be postponed indefinitely is most unlikely. Section 2 provides a mechanism for a rapid resolution, and that is more likely used when the sum involved is substantial. So, although Professor Merkin sort of identifies it, he doesn't seem to regard it as a particularly serious problem.
He doesn't offer a legal solution.
He doesn't offer a legal solution. I have got one. I have got 1 or 2 legal solutions. I think it's part of my course submission 4, or maybe 5, or maybe later. But I have got a couple of ideas.
Should we break there then, Mr. Speary? 2 o'clock.